cross-examination of the witness evidence against Mazi Simon Ekpa from the prosecution. The prosecution is representing Nigerian government, and they are trying to adopt the same system they are using against Mazi in Nigeria. But however, everyone is watching with enthusiasm and the desire to know what goes on in every second of these cross-examinations, and also the management of the case by the trial judge. But one thing everyone has to understand is that the Biafrans, the Igbos, are children of God, whether someone believes it or not. But this has been magnified and brought to light by the prophet of the time, Mazi Nnamdi Kanu. When he says we are children of God, it has a deep meaning which many people do not understand, including his own followers. But a prophet knows his relationship with the God he serves. His prayers, his words, his behaviors, even in the courtroom, expresses his humility and relationship with the God he serves. But Nigerian government, representing the Babylonians of the old, do not understand. They wage war from time to time against the children of God, to the extent that they involve other foreign allies to go against the children of God. But what did God say to his children when they are in trouble? Let us see this from the Bible. Every Christian and the Jewish alike reads. When you go back to Isaiah 54 verse 17, it stated, I quote, "But in that coming day, no weapon turned against you will succeed. You will silence every voice raised up to accuse you. These benefits are enjoyed by the servants of the Lord. Their vindication will come from me. I, the Lord, have spoken," unquote. This is from the New Living Translational Bible. This means that no weapon forged against any child of God, any Biafran, in the pursuit of Biafran struggle will prevail. And God stationed them to refute every tongue that accuses them. This is their heritage as children of God, as servants of God. And this is their vindication from God himself, the God of the Igbos, the God of Biafrans, and the God of the Most High, who has witnessed all lies, all manipulations, all misstatements against the people of Biafra. What happened in Biafra and the millions of people that died are still in the vibration of the mind of God, and he will vindicate every Biafran that is facing trial, no matter wherever the court may be, in Nigeria, in Finland, and any other place in the world. That is the word of God. They must understand what God is doing with the Biafrans, and that is what we are going to see in the various testimonies. It took place in Nigeria, in the case between Mazi Nnamdi Kanu, ongoing with the Nigerian government represented by the Directorate of State Services, DSS. God said he will confuse the tongues of those who are going to testify falsely against his own children. And this is manifesting. It manifested now in Nigeria and across the border, getting to Finland, where another activist, Biafran activist, is being tried by the southern government that uses lies against its own citizens. And we will go to see what the news in Nigeria was before the trial of Mazi Simon Ekpa began on the 30th of May 2025.
The Finnish government commenced his terrorism trial. In November 2024, the Finnish government arrested Ekpa on suspicion of terror-related activities, including incitement to violence and terrorism financing. He was accused of using social media to incite violence and cause unrest in the southeast region as part of his secessionist agitation for Biafra. According to the prosecutors who are demanding a 6-year prison sentence for Mr. Ekpa, his activities. Interrogations, Mr. Ekpa denied ordering weapons for pro-Biafra groups.
From Nigerian president's own television house in Lagos, TVC, about the trial of Mazi Simon Ekpa. You have heard the charges from the TVC channel read by his reporter. So these are the charges from Nigeria and not from Finland. The Finnish government did not know anything about Ekpa until the government of Nigeria began to cry to them, helped by the British government, and then forced the Finnish government to go against Simon Ekpa. In order to do that, they used diplomatic relationship between the two nations. They used contracts to entice the government of Finland on oil and gas contract. And this is very, very wrong, based on the fact that Simon Ekpa, whom they forced the Finnish government to arrest, to prosecute, is about to face the trial as the Finnish government accepted their request. Therefore, giving contracts and giving everything and showing, on the other hand, as if it was the Finnish government that initiated these proceedings is very, very wrong. They try to induce, and inducement in a criminal trial of the prosecutors openly for public consumption is the first failure of such trial. It can be used as appeal or stoppage of such trial, because the first initial move of the government of Nigeria was to award contract on the 22nd of May, barely 8 days before the trial began. But however, that is not the basic for the moment. What is important is that the author of this very news is behaving as if it was the Finnish government is now the accuser, the real instigator of Simon Ekpa's trial. Now they are challenging the whole issue on the prosecutors. If anything goes wrong, like normal Nigerian system, they will all shift and blame Finland for whatever that happened. They will raise their hands up that they have nothing to do with that, but they are the people who instigated the trial. That is Nigeria and their lawlessness system of handling issues. This brings us to the testimony of witnesses brought by both the prosecutor and the defense. And this is going to be compared, and the narratives have opened the case of whether it is intimidation or terrorism charges, as more evidence are expected and more witnesses to come in the days of the trials. Let us hear the opening statement and what Nigeria introduced to the legal proceedings, as they are the owner of the case, what the Finland government is doing is to satisfy and prove the case of Nigeria, because it is the prosecution that we prove beyond reasonable doubt about their accusations or allegations. Let us listen.
Ekpa's legal trial in Finland began with a pre-trial hearing on May 31st, 2025, and the main trial has now been officially scheduled to start on June 11th, 2025, as announced by his legal team. Simon Ekpa is facing charges in Finland over his alleged role in leading an online separatist campaign advocating for the independence of Biafra, with Finnish prosecutors claiming that the actions potentially meet their legal definition of terrorism. Simon Ekpa's lawyer, Carl Gomez, issued a public statement confirming that his legal team is fully prepared for the trial and confident in the transparency of the Finnish legal system. During the May 31st pre-trial hearing, the court began reviewing evidence submitted by the Nigerian government, which the defense claims is weak, politically motivated, and potentially manipulated. Simon Ekpa's lawyer challenged the authenticity of the Nigerian government submissions, noting that the Finnish court has decided to re-evaluate and reassess all the information and evidence provided before any verdict. Witnesses from Nigeria are expected to testify against Simon Ekpa, with delegates already reportedly sent to Finland, but the defense remains skeptical of the credibility and objectivity of these witnesses. However, a critic has emphasized deep trust in the fairness and integrity of the Finnish judicial system, contrasting it with alleged corruption, bias, and manipulation in Nigerian courts. The defense team believes that Simon Ekpa will be vindicated, asserting that the terrorism and insecurity in Nigeria long predated his involvement in the Biafra movement, which only began around 4 years ago. The critic accused the Nigerian government of fabricating evidence and spreading propaganda to criminalize Simon Ekpa and suppress the Biafra movement. Meanwhile, many critics are with the confidence that Simon Ekpa will walk free, stressing that the international community is watching and the trial in Finland will be transparent, just, and immune to external political pressure. Spectacles steeped in the sensitive tensions of ethnicity, nationalism, international diplomacy, and the collision between political ideology and national law. Of Simon Ekpa, a Nigerian-born Finnish citizen and political activist, had officially begun. Over the past 4 years, particularly in southeastern Nigeria, where he positioned himself as a spokesperson and self-proclaimed leader of a faction of the Biafra independence movement. And vocal condemnation of the Nigerian government made him both a symbol of resistance to some and a dangerous agitator to others. Finland, thousands of miles away from the southeastern towns of Enugu, Abakaliki, Onitsha, and Owerri, Simon Ekpa used the comfort and protection of European free speech laws to push messages that Nigerian officials insist have destabilized their already delicate national security situation.
Then what happened in the courtroom on arrival of the defendant, Mazi Simon Ekpa, on the 30th of May?
At the courtroom, a heavily anticipated phase of this legal confrontation took form in an initial hearing that lasted several hours. It wasn't just a procedural formality, it was a revelation of the complexities and contradictions that surround this trial. The prosecution, led by Finnish state attorneys working in coordination with Nigerian government liaisons, began to present preliminary evidence meant to establish a foundation for what they described as acts tantamount to terrorism under Finnish criminal law. The Finnish prosecutors acknowledged that this was not a typical criminal trial. They were dealing with a case that was as much political as it was legal, and the ramifications stretched far beyond Finnish soil. Simon Ekpa's defense team, led by his principal lawyer, Carl Gomez, a introduction of several pieces of evidence. Carl Johannes Gomez argued that the materials submitted by the Nigerian government were not only weak and speculative, but they bore hallmarks of political interference, manipulation, and outright propaganda. He told the presiding judge, in no uncertain terms, that the evidence had not been gathered under conditions that met Finnish standards of legality and fairness.
This brings us to the cross-border investigations in the EU. From the Defense Counsel of Mazi Simon Ekpa on the admissibility or the genuineness of the evidence collected from Nigeria. There are rules of collecting evidence in non-EU states or what is called cross-border investigations. This ensures that the admissibility of evidence must comply with the EU rules. Efficient and functional law of enforcement with clean records of protection of fundamental human rights by the country where the investigations are to be made in accordance with Article 6 of the European Convention on Human Rights, ECHR, and Articles 47 and 48 of Fundamental Rights of European Union, CFR. It means that it must be ensured that evidence gathered in cross-border investigation does not lead to its unlawful or unfair use, unquote. On the other hand, the defense lawyers must participate in evidence gathering, though the procedural framework determining the role of defense lawyer in evidence gathering varies across the European Union. Therefore, transparency is highly required. That was why the Defense Counsel of Mazi Simon Ekpa questioned the evidence coming from Nigeria. One, Nigerian system is full of corruption. Two, he did not participate in the gathering of the evidence. Three, the investigators from Finland relied on what Nigerian government provided for the prosecutors, which they considered not eligible for admission as evidence in this very trial. That is the effect of a country being known for corruption, being known for insincerity, being known for manipulations and biasness, and also considering the Igbo-Phobia system that are against the southeastern region in Nigeria. All those factors are considered by the Defense Counsel before the admissibility of this very evidence, which are gathered and given to the Finland police. Let us continue to hear from the Defense Counsel of Mazi Simon Ekpa.
He emphasized was the fact that many of the witnesses expected to testify against Simon Ekpa had reportedly been assembled through questionable processes and under suspicious circumstances within Nigeria. During a brief recess, observers in the courtroom noted the striking calmness of Simon Ekpa. Yet again, after the recess, he reminded the Finnish judge that the entire campaign of Simon Ekpa only began around the year 2021, while terrorism and banditry in Nigeria had been a growing crisis for over a decade prior. To link Simon Ekpa directly to the collapse of security in southeastern Nigeria, he argued, was to ignore years of structural failures, political marginalization, and ethno-religious tensions. Carl Johannes Gomez added that the Nigerian state had failed to address long-standing grievances in the region, and that people like Simon Ekpa had emerged as consequences, not causes, of that vacuum. The prosecution countered by emphasizing that it was not just about historical grievances. They maintained that Simon Ekpa's recent online broadcasts, particularly those aired in the days leading up to sit-at-home coincided with deadly attacks on public officials and civilians. The prosecutors stated that even if Simon Ekpa had not explicitly ordered violence, his rhetoric created an atmosphere that encouraged it. They introduced clips of live streams and social media messages, some of which used inflammatory language that could be interpreted as a call to resistance. Carl Johannes Gomez was quick to interject that Finland's constitution and the European Convention on Human Rights protected freedom of expression. He argued that no specific broadcast presented direct instructions for violent action. He said that political speech, especially from exile, must be given a wider berth, particularly when viewed in the context of government repression. The prosecution responded by asking whether such protections still applied when speech potentially led to human harm. The judge, in a moment that showed the Finnish judicial system's commitment to neutrality, reminded both sides that this was still a pre-trial hearing. The evidentiary burden had not yet been met. She indicated that all evidence, including documents, video materials, and witness testimonies, would be subject to thorough re-evaluation before the trial officially began on the 11th day of June. In the quiet moments after the judge's announcement, there was a perceptible shift in the room. The tension had not dissipated, but a temporary clarity emerged. The pre-trial hearing had succeeded in exposing the depth and difficulty of the legal questions at hand. More importantly, it set the tone for what would follow. This was not going to be a quick trial, nor would it be easily forgotten. A small group of Biafran sympathizers gathered peacefully under the cold Finnish sky. They held placards written in English, Finnish, and Igbo. One read, "Truth cannot be imprisoned." Another simply said, "Justice for Simon Ekpa." Among them were students, migrants, and activists who believed that Simon Ekpa represented more than himself. They believed he stood for decades of Igbo resistance, for the voices silenced since the end of the Nigerian Civil War in 1970, and for the new generation of digitally connected, politically aware diaspora Africans. The pre-trial as a victory, a sign that international mechanisms were finally acknowledging their concerns about what they called online radicalization and cyber-terrorism. But others worried that the entire process might backfire. They feared that should the Finnish court find Simon Ekpa not guilty, it would embolden separatist movements not only in southeastern Nigeria, but potentially in other regions such as the Niger Delta and the Middle Belt. Nigerian newspapers and television programs buzzed with heated debates, while pro-government analysts insisted that Simon Ekpa must be held accountable. Civil society voices asked hard questions about Nigeria's own justice system. A moral position to ask another country to punish a political dissident when it had consistently failed to guarantee the rule of law at home. Others asked why, if Simon Ekpa was so dangerous, the Nigerian government had not made a formal request for extradition. The Finnish government had maintained that Simon Ekpa was a citizen of Finland and thus enjoyed the full rights and protections of that status. Extradition, they reminded, was not only politically sensitive, but legally improbable, without irrefutable proof of criminal acts committed under Finnish jurisdiction. June approached. Behind the scenes, things continued to develop. A small team of Nigerian government representatives arrived quietly in Helsinki, reportedly including officials from the Ministry of Justice and the Department of State Services. Their mission was to coordinate with Finnish prosecutors and ensure that the testimony of witnesses from Nigeria would meet legal standards. But questions immediately arose about the witnesses themselves. Who were they? Were they selected from the Nigerian military or police? Were they civilians affected by violence allegedly tied to Simon Ekpa's broadcasts. Were they coerced? Were they compensated? The defense team, in several pre-trial filings, hinted that it would seek to cross-examine these witnesses rigorously. They warned that the entire foundation of the Nigerian government's case depended on credibility. If the witnesses turned out to be partisan, compromised, or contradictory in their accounts, then the prosecution's case could unravel. In Finland, Nigeria, and the United Kingdom. Simon Ekpa himself remained largely silent in public statements after the pre-trial. His legal team maintained that it was better to let the legal process unfold without distraction. But a few close supporters who had spoken to him in private revealed that he remained confident, calm, and fully aware of what was at stake. He was not just fighting for his personal freedom, they said. He was fighting for recognition of a people's pain, for the right to dissent, and for the idea that even exiles have a voice. The closing remarks at the May 31st pre-trial gave perhaps the most important statement of the day. She said that while the court acknowledged the political implications of the trial, it would operate strictly within the framework of Finnish law and the European human rights tradition. This trial, she said, would not be influenced by diplomatic lobbying, political symbolism, or historical baggage. The court, she affirmed, would do what courts are meant to do: seek the truth, follow the law, and deliver justice.
With today's preliminary knowledge of what is happening, then we will bring more of the updates. Thank you for watching, and also remain positive and hopeful. And finally, thank you for tuning in till we come to you with